One of the recent controversy is the mercy petition pleaded by Pererivalan before the Tamil Nadu governor, and which later turned into heated controversy between state and center and judiciary, and also the controversial role of governor. First, we have to understand about the clemency power of president or governor. So, if the Supreme Court turns down the appeal against capital punishment, a condemned prisoner can submit a mercy petition to the President of India and the Governor of State under Article 72 and 161 of the Constitution. Under these articles, the Governor have the power to grant pardon, reprieves, respite or remission of punishment, to suspend, remit or commute the sentence of any person which is convicted of any offense. Neither of these powers are personal to the holder of office but are to be exercised under Article 74 and 163 respectively. Means whoever be at the post of president and governor respectively. Also with the aid and advice of council of minister. Need for application of mind to ensure justice. Now these clemency powers can be exercised on a wide range of consideration, on some protean occasions, final safeguard against possibility of any judicial error or sometime miscarriage of justice. This casts a heavy responsibility on those wielding this power and necessitates a full application of mind, scrutiny of judicial record and wide inquiries in adjudicating a clemency petition, especially one from a prisoner under a judicially confirmed death sentence who is on the very verge of execution. Now we have to understand the meaning of pardon, reprieve, respite, commutation and remission. In pardon, it affects both the punishment prescribed for the offense and guilt of the offender. A full pardon may bolt out the guilt itself. Reprieve means a temporary suspension of the punishment awarded by a court of law. Respite means postponement of sentence of punishment. Commutation means changing the punishment from one category to another, such as changing of death sentence to life imprisonment. Remission is the reduction of amount of a sentence without changing its character. Now the question arises, is judicial review available on clemency powers? The court can interfere if it found that the decision has been taken without application of mind or the decision has been taken on extraneous or irrelevant consideration or due malefides, decision taken in bad faith, or if the decision suffer from arbitrariness. In the case of Ipuru Shudhakar was a government of Andhra Pradesh, the Supreme Court laid down that judicial review under Article 72 and 161 is available on the following ground: that the order has been passed without application of mind. Second is, the order is nullified. Third, the order has been passed on extraneous or wholly irrelevant consideration. And the fourth one is, the order suffer from arbitrariness. The court also emphasized that for effective exercise of judicial review, reasons for exercise of power under these articles must also be provided. Besides, it held that pardon obtained on the basis of manifest mistake or fraud can also be rescinded or cancelled. The court further elaborated that if power under Article 72 is exercised on irrational, irrelevant, discriminatory ground or in bad faith, then in such cases, court can examine the case and intervene if necessary. Does the President enjoy discretion while granting pardon? Now our next question is, does the President enjoy discretion while granting pardon? So, power to pardon vested in the President shall not be exercised independently without the aid and advice of Home Minister. Like in the case of Maruram was a Union of India, Supreme Court held that Article 72, the President cannot take an independent decision or direct release or refuse release on his own choice. This has been done to avoid any decision made on arbitrary ground or on some partial ground of religion, caste, color or political loyalty. Supreme Court on validating capital punishment. Article 21 of Indian Constitution ensure the fundamental right to property and liberty for all persons. It adds, no person shall be deprived of his life or personal liberty except according to procedure established by law. This has been legally constructed to mean if there is a procedure which is fair and valid, then the state by framing a law can deprive a person of his life, while the central government has consistently maintained it would keep the death penalty in the statute book to act as a deterrent and for those who are a threat to society. The Supreme Court too has upheld the constitutional validity of capital punishment in rarest of rare cases. Like in Jagmohan Singh was a state of Uttar Pradesh. This case was in 1973. Rajendra Prasad was a state of Uttar Pradesh. The case in 1979. The final and benchmark case of Bachchan Singh was a state of Punjab. The case of 1980. The Supreme Court affirmed the constitutional validity of the death penalty. Said that if capital punishment is provided and the law and the procedure is a fair, just and reasonable one, the death sentence can be awarded to a convict. These will, however, only be in the rarest of rare cases, and the court should render these will, however, only be in the rarest of rare cases, and the court should render special reasons while sending a person to the gallows. So now, after this background information of mercy petition and regarded laws in India, let's understand the latest controversy over the disposing of the mercy petition of Pererivalan. So in order to understand, let's go back to the year 1994 when Pererivalan was convicted in the assassination case of former Prime Minister Rajiv Gandhi and subsequently handed out the death penalty. Later, in 2003, Pererivalan pleaded for a mercy petition before the President of India under Article 72. So, basically, Pererivalan wanted that President should commute his death sentence to life imprisonment. So, accordingly, he filed a mercy petition before President. But there's no bounding of time or time limit within which the President has to decide on a mercy petition. So, until 2014, President of India did not decide on this particular petition. Further, for 11 years, President of India kept the decision pending. So, this in turn turns into life imprisonment suo motu. And Supreme Court also favors this commute of Pererivalan death sentence to life imprisonment. Later, in 2015, a pardon request moved by Pererivalan was not considered by Governor. However, Supreme Court order on a related petition in September 2018 clarified that the Governor was deemed fit to decide on the pardon. Thereafter, a recommendation to remit his life sentence was advised by the Cabinet under Article 161. However, the Governor's decision is still pending. Now, what is the center's stand on this case? The plea for pardon and release should go to the President instead of the Governor. as the case is being investigated by a central agency. Now, what is the petitioner's argument? A convict was free to choose between the president and the governor for pardon, referred to the constitutional bench, Judgment in the Union of India versus Sriharan 2015, which shared the exercise of executive clemency was wasted in the president or the governor. Center's rejection in 2018 of the Tamil Nadu government proposal to remit the sentence of the convict under section 432 of CRPC did not stop the convict from separately moving the governor for pardon under Article 161. Now, what Supreme Court's observation in that matter? The Supreme Court termed the governor's delay extraordinary. It also noted how a decision was not forthcoming despite the state government's recommendation. It needs to be noted that the governor cannot reject the state recommendation, but there is no time prescribed to take a decision. The governor had already written the file to reconsider the government's decision, but the government stood by its decision. Now, for further elaboration on that topic, what Pererivalan actually wants. Firstly, he moves to the President of India for commuting his death sentence to lifetime imprisonment. Then, summately, the case is pending for 11 years and his death sentence automatically converted into life imprisonment. Then he goes to Tamil Nadu's governor for further pardon of his sentence. So the conflict is whether governor is eligible to pardon any convict from death sentence or not. The governor of Tamil Nadu right now sent the decision to be decided by the president or before president. One more question here arises is whether governor is designate to pass such decisions to president. As for any bill, if governor want to bill within his office or for further consideration, sent it to president, but mercy petition and bill are two different things. So here this also not clear whether a mercy petition from governor should be sent to president for consideration or not. So let's focus on few limitation on pardoning power of governor. So the president cannot exercise his power of pardon independently of the government. He has to act as per the aid and advice of the Council of Ministers. In several cases, the Supreme Court has ruled that the President has to act on the advice of Council of Ministers while deciding mercy pleas. These include Maruram was a Union of India in 1980, which we already covered earlier in this video, and Dhananjay Chatterjee was a state of West Bengal, the case of 1994, and this is in under Article 72. Now, governor's pardoning power under Article 161. The governor of the state shall have the power to grant pardon, reprieve, respite or remission of punishment, or to suspend, remit or commute the sentence of any person convicted of any offence against any law relating to a matter to which the executive power of state extend. Now, what's the difference between pardoning power of president and governor? The scope of pardoning power of president under Article 72 is wider than the pardoning power of governor under Article 161, which differ in following two ways. Court martial. The power of president to grant pardon extend in cases where the punishment or sentence is by a court martial, but Article 161 does not provide any such power to the governor. Death sentence. The president can grant pardon in all cases, whereas the sentence given is the sentence of death sentence, but the pardoning power of the governor does not extend to death sentence cases, and accordingly, what Pererivalan is convicted of death sentence, but his punishment turned into life imprisonment. Now he is pleading for commutation of life imprisonment also. So all in all, he goes to governor for pardoning of a death sentence. So whether governor is eligible to grant him pardon or not, or what this case has effects on center and state relation, center and judiciary's relation is all the point we have to look in the future. So thank you. That's all for today. For more such interesting videos and facts and